Distinguished guests, particularly our distinguished guest of honor, Professor Rosemarie Antoine, good evening. On behalf of my colleagues at and the students of the Eugene Depute Law School, thank you for choosing to spend this evening with us. At this lecture series, which pays tribute to the late Honorable Eugene Depute QC, advocate, playwright, musician, we invite eminent jurists to share their views and experience on relevant legal socio issues. I have no doubt that every one of the hundreds of persons in this webinar has paused at some point in the past 2 years to reflect on some aspect of their lives, to consider or reconsider what could be done differently. Reflecting, reimagining, redirecting, recreating is what we've all been required to do. Last year, in introducing our distinguished speaker, I observed that the 3 previous presenters had all included the word change in their chosen topics. Last year, we looked at AI and ADR, the new frontier. In fact, 7 of the past 11 presenters spoke to various issues of development, change, advancement. That, in my view, is testimony to the dynamism of the law. So here we are again, being challenged to reimagine law post-COVID-19. I am looking forward to a stimulating lecture and to the conversation afterwards in our discussion period. I hope that you find the time to be valuable. It is my pleasure now to invite Mr. Clive Guy, Senior Tutor 2 at EDLS, to introduce our guest of honor. Clive?
Thank you very much, Principal Bastian Galanis. And of course, as we like to say, protocol having been established, everyone having been greeted, I will simply say good afternoon to one and all throughout the region and wherever in the world you are logging on from. And it is indeed my distinct pleasure to be able to introduce Professor Rosemarie Belle Antoine today. And when we asked for the short bio, I smiled, because then I said, okay, Clive, how are you going to be able to deliver all of this in a very short and quick manner? Because of course, Professor Belle Antoine's accomplishments are so much. And I want to start with this. Just before we started, I said, when I have to call you Pro-Vice Chancellor now. And she reminded me, no, I'm still professor. I said, but PVC sounds better. So Professor Rosemarie Belle Antoine, of course, is the Pro-Vice Chancellor of Graduate Studies and Research. She's the former Dean of the Faculty of Law, UWI St. Augustine, and chaired the Professor of Labor Law and Offshore Financial Law. She is an Oxford and Cambridge scholar and holds a doctorate in law from Oxford and an LLM from Cambridge with her LLB from UWI. She, of course, has certificates in international human rights from the International Institute of Human Rights in Strasbourg. And of course, Professor Antoine, as an attorney, is an award-winning scholar and author, international consultant, and of course, temporary Court of Appeal judge and activist. She was elected president of the Inter-American Commission on Human Rights, Washington, the OAS Rapporteur for Persons of African Descent and Discrimination, Rapporteur for Indigenous Peoples, and head of the OAS Economic, Social, and Cultural Rights Unit. She was CARICOM Chair on HIV, Migration Chair of the CARICOM Regional Commission on Marijuana. She is President of the Family Planning Association, a Cambridge Fellow, a member of Trinidad and Tobago's Industrial Relations Advisory Committee, an Honorary Fellow of the International Society for Trust Practitioners, that is STEP. And of course, she's the only Caribbean person and a trustee of the London IPPF board. I must also mention to you, of course, Professor Belle Antoine has served throughout the Caribbean, the United States, the UK, Venezuela, and on several international organizations, of course, for the United Nations, the European Union, the IADB, the World Bank, ECLAC, and other such entities. She is very much interested in criminal justice, anti-discrimination law, HIV law, education, narcotics, labor law, human rights, free movement of persons, financial law, health, gender, and of course, money laundering and anti-corruption law. And I'm surprised when Principal used the term change agent, that most of our last speakers had that in there as part of their topic, because given her that she's one of the foremost labor law experts in the region and the leading authority in the region in international financial law and HIV law, Professor Belle Antoine has always and continues to be referred to as a change agent. And I really like that. And I read here now from her short bio, of course, that she's very interested not only in human rights, she enjoys painting, gardening, and a trained classical singer. But I think what Professor Belle Antoine forgot is that she is a lover of animals. She loves her dogs, particularly. She's particularly fond of her dogs. And Professor Belle Antoine, along with Sir Dennis Byron, former president of the CCJ, recently quoted that report for the heads of government of the OECS with regard to COVID-19 vaccination and perhaps the mandatory nature of same. So I have spoken enough for the evening. Brevity is the best form of advocacy. I step aside and I turn the floor over to Professor Rosemary Belle Antoine. Let us welcome her, please.
Thank you so much, Clyde. Good evening, everyone, Principal Gaston Gallas and your entire team and everyone in our audience. I'm so delighted to be here. I would have preferred to be in the Bahamas because we know it's better to be there, but next time. So what is law? How do we imagine law? What is the purpose of law in society? I would say, of course, to resolve conflict and disputes, but also to re-engineer society. And so when that society changes, even if it's suddenly and dramatically, law should be able to withstand the shock and provide solutions. The COVID-19 pandemic experience, I think, uniquely confronted the legal infrastructure, and it forced us to reimagine law and policy in several arenas. It challenges us to reevaluate the very raison d'etre of law. And I think it will usher in a very fascinating jurisprudential phase, lots of paradoxes and dilemmas. And we need to see how did our law measure up. So in my paper, I will look just not at the nitty-gritties, the black and white letter of the law, which I know some of us love. So some concrete suggestions for law reform and so to fill those gaps. But I also want to focus on some broader conceptual issues about law and its place in society, extending to the philosophies which must envelop law if it is to have any meaning and purpose, and perhaps where we fell short. And I do believe that our current conceptions of law in some respects failed us, not just in the letter of the law, but also the spirit of the law, what law should mean for societies. And especially when law was not accepted during the pandemic, perhaps not understood. And that is something we're familiar with. A society sometimes does not feel itself bound by certain laws, doesn't accept it, and they become unenforceable. And I'm thinking now, for example, of the cannabis, the marijuana laws, which of course were breached more often than not. And I certainly do think they were unjust laws. So in terms of COVID, some of these, the restrictions, the vaccine mandates and so on, fall into that category. And we do see the dangers of formulating law in very narrow, rigid prisms, too divorced from its social imperatives and nuances. So it needs, I think, the law to reclaim and to fulfill its true purpose of resolving those difficult issues in society. The legal disciplines that were front and center in the pandemic were labor law, health law, and of course, human rights. And I want to start with labor law. And I think we've been neglecting to discuss this issue somewhat. I have long lamented that the contract model for defining employment is inadequate to capture effectively the world of work and its complex relationships. This was, I think, manifested very clearly in the pandemic in myriad ways and demonstrates to me the need to reimagine labor law precepts to better serve workers and communities. It might seem to be a radical view, but given the now multifaceted and innovative context of the work sphere, as well as the emergence of a rights-based framework for work and labor, which originated in the ILO, and more recently, the concretization and increasing justiciability of economics rights, that whole economic, social, and cultural rights issue, such as the right to work, to health, to education, and so on, I do believe that my comment is apt. After COVID, there are even more rationales for challenging the rather limiting contractual foundations of work and labor. And a starting point is the issue of maintaining job security. Here we see that the pandemic paves the way for legal doctrines to be invoked, which will bring insecurity, involving widespread layoffs and terminations. So whether we look at force majeure as a legal doctrine, frustration of the contract, the redundancy or retrenchment severance laws, layoff or protection clauses, the extent to which COVID-19 rendered or renders, I'm not too sure whether to say past tense or present. Are we at the end? I'm not clear. I hope so, that we end of the pandemic. COVID-19 has rendered our labor rights framework vulnerable. Some would say undermined it, but certainly raises deep concerns in terms of job security and the right to work. And it involves a balance that needs to be struck where there's a financially challenged, pressured labor environment as a result of the pandemic. And of course, labor rights are part of our democratic governance. It is particularly significant in legal constructs which have typically not been seen as favoring labor equilibrium. The right to work is therefore severely compromised. All of the carefully constructed protections, dismissal law protections, duty of the employer to provide work, to pay for work, etc., have had to be made subservient to the pandemic. And labor law is as yet unclear as the appropriate legal rules that apply. Some of them, I suggest, can only be formulated appropriately within a rights-based framework and not a contract formulation. But the existing constructs, which are built on contract, and of course, contract itself based on the preservation of property and capital and not producing equilibrium, are not fit for purpose in pandemics and emergencies and disasters, where we have to focus on the vulnerable and in protecting rights and equality. Moreover, we had very unclear obligations to contest. So for example, who should foot the bill when workers are not able to report to work? Are there legitimate grounds for termination? Rarely we saw inadequacy in our legal framework. Moreover, termination options are not desirable. And I think even employers would agree, they don't want to terminate. And of course, they would further obstruct developmental objectives. So termination should be the last option, but often the laws leave employers with little choice, since other less intrusive approaches, such as shared sacrifices, like reducing your pay, reducing your hours of work, sending you off on compulsory leave, or taking your vacation leave in exchange, things like that, cannot be or cannot easily be interfered with unilaterally under our traditional contract-based model of employment, because that would result in a contractual breach and damages. So it forces termination. So yet the rigidity of the contract model, it led many employers to simply take the easier route and terminate workers. Ironic that it's actually easier to terminate than to do some of these things. Trying to maneuver very uncertain principles to do with flexible work hours, leave, vaccine mandates, and so forth, leading to job insecurity. So law was, I would suggest, in many instances, a disincentive to employment. It was not proactive. It wasn't far-reaching enough to adequately contemplate disasters and other emergencies. Some workers, as I had feared from the beginning, in fact, terminated workers, and then they rehired other workers, or I imagine sometimes the same workers on different terms. They were asked to accept upfront different contractual terms, including that you need to be vaccinated to work here. So you don't have to worry about changing terms. But this lack of flexibility in the contract model proved to be counterproductive. Of course, there were some really great employers who kept their workers on, gave them full pay and so on, but that was not because of legal imperatives, and the legal system cannot rely on largesse. Similarly, for redundancy, where you have an uncertain legal framework which is presenting very starkly different choices. On the one hand, if you go towards force majeure or frustration as an option, the worker is left with nothing. If you decide, okay, I'm going to go for redundancy, severance benefits are, you're entitled to severance benefits all over the region. And for those of you who are not lawyers, force majeure and frustration, those will speak to situations where extraneous and unforeseeable circumstances, including acts of God, occur, which make specific performance impossible or could cause delay. And so then you can terminate or lay off without compensation, except if it's specifically provided for. Of course, you will have to try to mitigate. So the whole issue of going on to remote work would have been one type of mitigation. Redundancy, of course, you need legitimate economic reasons to be able to terminate and due process. But COVID, because it compromised these basic obligations to provide work on the part of the employer, the workers' duties to work and to cooperate, and of course, pay being dependent on the work done, all of these were compromised so that frustration could easily have been argued and satisfied. And even the ILO recognizes that. We know too that these doctrines, frustration, etc., force majeure, did not apply and does not apply evenly across the different categories of workers. So there's a difference between salaried workers and non-salaried workers, and it also depends on the workplace context. So that those workers who were prevented or cannot work due to physical distancing, then of course they're different to those who can afford to stay at home and carry out their contractual duties. No frustration will occur there. There may be less productivity, which is another issue for labor law, how to measure this. But it is those workers who can't perform at home, often blue collar jobs, low income jobs, where workers are already vulnerable. So the lockdown for them meant no work and no pay and possibly termination. We do know that over the world, all over the world, workplaces, including universities, opted to take severe measures such as job cuts and furloughing and layoffs and salary cuts and so on. And we haven't had many cases or cases testing these. So I'm assuming that these justifications like frustration and etc. will hold in a court. But the end result, whether it is force majeure, whether it is redundancy, frustration, these are all undesirable except as a last resort. So law and legal policy, I would suggest, needs to be reimagined to provide for sufficient buffers in these kinds of contexts. And we know that termination is not a beneficial outcome, even in the wider financial context for the economy at large scale unemployment, etc. So going forward, we have to renegotiate contracts in a different way. We have to be able to have this kind of flexibility. We have to target alleviating financial pressures by being able to trim employment costs, being able to exchange different kinds of arrangements in the work contract or whatever system we may want to do, a non-contractual system. And also I would suggest that we need to have, where termination is inevitable, some preference for rehiring persons. Similarly, in terms of layoffs, and this one really is quite ironic. So the laws that were included in some jurisdictions to attempt to protect workers in layoff situations and to prevent the abuses we had seen before actually ended up with the potential to harm workers in the pandemic. So to give you an example, your own law in the Bahamas, which a couple of years ago I actually amended, I was the consultant, to introduce these provisions for layoff so that a worker, an employer couldn't keep you for long periods without any work, supposedly temporarily, but you get nothing, but would be forced after a particular period of time. In some countries, it's 103 days, some it's 12 weeks, as it's in kits and so on. After that, you would get entitled a severance benefit. just to ensure that there's no exploitation going on. And also, of course, to ensure during layoff periods that your employment is continuous and is not broken. What happened in the pandemic, because it stretched on for so long, it tested those provisions. So the 103 days and the 12 weeks and so on was going on, and we had to then, and some did and some didn't, hustle therefore to have provisions, new provisions to extend those layoff periods to protect workers. So again, we weren't able, law was not able to contemplate these emergency kinds of situations and had no sorts of emergency clauses in them. We've seen also this new jargon of the furlough, which I'm yet to understand. It's not part of our English law, basically giving lots of leeway to the employer to do a whole host of things. Perhaps it's something we can keep in the future, but we do need to ensure that we insert adequate protections for job security, because you don't then want to undermine and to disturb all of these dismissal protections that we have already. Most of all, I think, is the need for some kind of social welfare or social cushion in these kinds of experiences, these kinds of pandemics and disasters. That's a new paradigm. And we need to reimagine our legal policy frameworks to accommodate and to ameliorate these inequitable impacts of labor vulnerable situations, have more sustainable solutions. So quite apart from preventing job insecurity, adequate social welfare provisions, instead of what was actually very ad hoc bailouts in some countries. So some kind of unemployment insurance, severance pay funds, long-term social security measures, which are capable of offsetting disasters as part of the labor law framework, that would be more feasible. And this is not far-fetched in the region, because we do have a few countries that have things like that. So for example, Dominica, Barbados have similar kinds of provisions. And this is even more warranted, given that the bailouts, as they were called, tended not to focus on the most vulnerable in the labor context. So for instance, the informal sector, which accounts for a large component of the poorest, they were left out of these forms of state assistance by and large. And notably, too, most of our vulnerable populations are those who work in the informal sector, including domestics and so on, and typically not protected under labor law. So some of these low-income workers, they were left defenseless on their own. And even if they did have access to grants, it required cooperation from employers, and that created headaches in some instances. In many cases, government grants were actually aimed at entrepreneurs and not at vulnerable workers. So the pandemic presents a good opportunity to revisit these laws to get a better deal. And of course, we don't know what will happen in the future. It might be things to do with hurricanes, God forbid, all of this climate change. So this may not just be a one-off kind of situation. And of course, we need more flexibility in terms of our contractual terms and conditions in our contracts. So although it is settled law that an employer cannot unilaterally change terms and conditions except in well-defined circumstances, and of course, there you need to ensure to prove that there was a breach of the contract. It is very difficult. And so we need to be able to have clauses for these emergency contexts to give this kind of flexibility. I would suggest also with the blessings of unions, because you don't want to undermine your collective bargaining relationships. So some of the things that happened in this pandemic that demonstrates this need, employers wanting to limit their hours of operations, to say to the public, which inevitably meant that the employees' work hours were also reduced, and these could have constituted breaches of law. We had examples where, I know St. Kitts was one. I was at an ILO seminar where they actually supposedly with consensus, although they didn't get full consensus, and with the unions agreed to use their vacation leave and so on, which is a very sensible thing to do. These are the kinds of arrangements that we can do, ameliorating measures. Not even sick leave, we are clear, can be used for pandemic situations in the context. That is still a big gray area. So we have seen that in structural adjustment situations, if we want a comparator, the question of necessity was held to be something that could be used, at least in the public sector. And I'm thinking of the King case from Barbados, to be able to change terms and conditions out of necessity. But that is a very unique case, and it's better for us to plan to go forward, because it is indeed very uncharted waters. So of course, these new kinds of clauses would have to be renegotiated in good faith with unions and so on. And then there were simply those kinds of situations for which there was no legal provision whatsoever. So remote work, we entered into a whole new realm here, glaring gaps in our regulatory framework. We had never contemplated this, certainly in a widespread scale. And with it came up a plethora of new questions. How do we measure how much work you're actually doing, productivity, kinds of costs, how are facilities to be provided for, whether it's your electricity and so on, how is health and safety to be measured and monitored? There are a whole host of questions that have now arisen, for which labor law and I imagine other kinds of law would now need to find the answers. Once again, too, we had to confront the very limiting nature of the concept, the very concept of an employee as opposed to a worker. Labor laws tend to offer protection only to employees, a very narrow construct, whereas in many others who work, who toil, are rendered vulnerable. Recent cases like the case of the Uber service in the UK, it has attempted to humanize this construct and try to reflect more accurately the realities of the marketplace. Because Uber claimed that their drivers were independent contractors and they were not employees, despite the arrangements, which, it was their cars, their tools, their very strict control. But of course, the reason they did that was to avoid having to pay them benefits. But the courts disagreed. And these are very common exploitative types of arrangements that we see in the Caribbean as well. And they require social responsibility measures. In the same Employment Act that I mentioned to you, I worked on in 2017, we did attempt to insert a clause in there about sham contracts to prevent against that. But during the pandemic, that approach would have been very useful because so many workers were left out. And the paradox is that it was precisely those who need protection the most, who needed protection the most, got it the least. So the independent contractor, the informal worker, where every dollar counts, or the daily paid with little job security, they suffered the most from lockdowns and restrictions. Even the coconut vendor, the nuts man, the sweet lady, the higgler, the hotel worker, they were often forgotten when there were cushions, and they were left to the vagaries and whims of the employer's largesse or the market. And we need to understand the reality of our Caribbean workplace and what percentage of them are unprotected, and frame laws which will speak to this. So the law should be imagined to include that reality, the existence of what we term now as livelihoods, as opposed to work and workplaces. We talk about livelihoods as opposed to faceless contracts. Even our health and safety laws were not as strong as we thought they would be. And there are still gaps here, despite clear duties, both under statute, as in your own law, and under the common law, for both employers and employees having duties toward health and safety in the workplace, but many gaps. So we still don't know, can workers refuse to attend work at all because of threats simply by venturing out to work. Suppose I have to take a public transport and I say, well, no, I don't want to go because that will endanger my life. And that actually goes beyond mere health and safety laws and goes into the health regulations, etc. Even now, I'm told some people, although we've lifted so many restrictions, some people are afraid to go out to work. So in the States, some people have left the workplace altogether, things like that. Can a worker refuse to work alongside an unvaccinated worker claiming health and safety issues? Who is to pay for mandatory testing if a worker refuses a vaccine? That was a big one, it's still a big one. The extent to which consultation requirements will impact on these health and safety measures. So do you need to go through a union for all of these things? There's still unanswered questions. We now need to reformulate these answers. But perhaps it was in the area of human rights that the most dramatic tensions of the COVID context were revealed. Whether we're talking about restrictions, border lockdowns, blocking citizens from their own country, states of emergency, religious freedom, safe zones, mandatory vaccines, claims of discriminations, so many, and claims of rights violations and asserting of rights, it's my human rights, seem to roll off the tongues of our Caribbean citizens. There is a bit of a paradox here. I spent years, decades, advocating for human rights, and people say, oh, human rights is about death penalty. At a time when we have finally accepted human rights as a key aspect of our democracy, it proved to be the greatest obstacle in the pandemic certainly in terms of the point of view of the state in pushing forward the health agenda. So we went from dissing rights to too much rights, perhaps. Of course, in my view, this is really because of a poor understanding of rights, and we seem to think rights are only about individualistic conceptions of rights rather than rights as a common good. Whereas the pandemic and issues important to public health and broad concerns of the right to health require us to go beyond the individualistic and have a very distinct majoritarian agenda. So from vaccine passports to lockdowns and so on, core legal principles must be retooled to address key issues. And they require legal solutions, which are not only part of a legitimate legal space, but also appropriate to a developing country faced with special challenges in a pandemic. So the question of how easily would our hospitals be overwhelmed is linked to the human rights response as to whether it being proportionate or not. And also in our countries such as ours, in many other areas, considering how uneven and inequitable the responses might be. So we do have a challenge to reimagine a human rights system, yes, grounded in internationally accepted norms, but shaped to fit these real life security, public health, and bread and butter issues. In my worldview, economic, social, and cultural rights are core to this discussion. And I see civil and political rights, the ones we're familiar with, equality, dignity, and so on, as dependent upon the promotion of economic, social, and cultural rights, such as right to work, right to health, and education, or at least inextricably linked, indispensable to each other, and essential to the rule of law in any society. I embrace the indivisibility of rights and also the justiciability, the enforceability of economic, social, and cultural rights. Some of our constitutions have started to include them, Guyana, Belize, Grenada, and so on. And I've written extensively about that, so I wouldn't say too much. In today's COVID's context, we can't escape a conversation about economic, social, and cultural rights and how these intersect with civil and political rights, in particular equality. And that must really inform the jurisprudence and our doctrinal principles. So it's not enough just to apply rules mechanically without responding to the real situations in people's lives. And interrogating these issues of access to equal rights and the restrictions that inhibit such access has to be part of that discussion. And the failure to secure those rights, part of the wider landscape of the COVID-19 induced threats to our conceptions of democracy and justice. But I think they are being illuminated, even if slowly. And equality is a core element here and grounded in that rule of law concept, which in itself I see as part of development. And I was glad, Clive, you mentioned development, other speakers, because everything we do now and say has to be grounded in development. And judges, policy makers, everyone, we have to understand this. So it cannot be divorced from these largest issues of development when you're making decisions. The pandemic brings a great obligation for us to anchor these policy decisions or judicial decisions in due process and equality, centering them in these larger economic and social issues of development, and both economic, social, and cultural rights and civil and political rights are to be viewed within this concept, equality and due process, rule of law, these concepts. And so it's not just having the rights on a piece of paper in a constitution, but ensuring that they are distributed equally and the goods, the public goods that go along with them are distributed equally. So in pandemics, in natural disasters, we have to look below the surface to identify the disproportionate impacts that exist and which we saw exist. We can't treat everyone identically because that will only perpetuate and deepen inequality. How did we do? Well, I think COVID really exposed very deep structural inequities in our region in terms of the access to rights, not limited to economic, social, and cultural rights, but that was there. Right to education, right to health, the right to water, and the right to work. And I've already mentioned a lot about the right to work. So the human rights framework has to address these structural inequities. And the important question on rights have to be evaluated within these broad contexts. Who gets access to online education, scarce adequate medical treatment, and so on. And it's also related to layered questions, other layered questions and contexts. Even questions relating to occupational segregation. The fact that certain people work in certain sectors which happen to be vulnerable sectors, risk sectors in the pandemic. Our janitors, the cleaners, the nurses, the bus drivers, the police. A lot of police guys died, police officers died, security officers, and so on. Even our prisons. Who are in our prisons and how such prisoners, including our migrant population in Trinidad and Tobago, who were detained often unlawfully, are treated in a pandemic, and whether they got access to rights, economic, social, and cultural rights. And generally, in terms of the link between the two, economic, social, and civil and political, for me, it is difficult to envisage meaningful equality and dignity if you have a hungry belly, if you can't afford a few cents to get transport to go into a health clinic or a school, if you don't have the luxury of staying home to work remotely, as the case may be. So we are also talking here, when we talk about the structural inequities, we are also, of course, talking within a subtext of poverty and marginalization. But too often poverty is invisibilized in our region, especially under this illusion of free education and opportunities for all. And poverty, of course, often aligned with race, sometimes I should say aligned with race indirectly. And when the pandemic started, I remember seeing these pictures of very long lines of persons lining up outside of a Catholic NGO in Trinidad, and they were wanting some basic food hampers, and I thought, oh, all these long lines, and the authorities, they weren't sympathetic because they didn't believe it. They were in denial. We said, oh, those must be Venezuelan migrants and not Trinidad nationals. So we didn't see poverty. Actually, it's one of the good things about the COVID. We were able to see poverty much more clearly and inequity much more clearly. And certainly, the rule of law, development, sustainable developmental goals, all of them look at these indicators: education, healthcare, poverty reduction, and they all also emphasize equal access. So the pandemic has accentuated and highlighted equality deficits in the region. And one of the most heartening things was the way the media, I don't know about the entire media in the region, but certainly in Trinidad and Tobago, they were doing these clips about children from poor communities trying to get access to online education. Some of them had to walk miles, literally, in the rural areas and in the sort of the urban ghetto areas. They didn't have a phone. Everybody has a phone. Everybody has a laptop. No, they didn't have these things. So some of them walked miles and miles to a little parlor to use Miss Mary's phone so that they could go to their class. It was really quite heartrending. And then these small business type persons who lost everything, who didn't have a penny, things like that. So we need to take this new awareness of these inequities and build it into our understanding of what equality is and what rights must mean. And other courts, and I keep saying it has to be part of the judicial process as well, how we interpret our constitutions and our rights instruments, because we do have equality clauses. And other courts have done it. In Canada and India, they have done things like this. Look below the surface to identify these disproportionate impacts. As we discovered to our peril, in pandemics and natural disasters, even simple regulations can have disproportionate impact. A simple thing that at what time you close your business, the hour you choose, could have huge negative impacts on certain sectors and render them more vulnerable, things like that. But perhaps it was in education that we saw the greatest disparities during the pandemic. We have always known that schools are unevenly resourced, especially those in rural communities and urban low income areas. And I think we were certainly desensitized to that. But this whole question of online and whose parents can help you maneuver all of those things I think presented us with a stark reality which we must address. And our response, um, even in terms of university, incidentally, my own students, the first thing I did was to have a survey when we went online. And I was shocked. 65 of my students, I did an audit right away once big lockdown, did not have a laptop or did not have internet access in their homes or in their area, because it's all dependent on also where you live. This is in Trinidad and Tobago, which is an oil-rich country. 65 out of like 300 students, 300 to 400, 300 and almost 400 students. That's a large percentage. And I hope, but I'm not convinced, that our policymakers have really internalized this, have cast an enlightened eye over it. I ask because I saw exams went ahead, CAPE, CSC exams went ahead last year. And I am not too sure what is going to happen for the thousands of disadvantaged children who had no laptop or no adequate service, etc. I don't know what we are going to do. It makes a mockery, I think, of free and equal education, what we thought was a protected right. And whether they are expected to approach life with these deficits or whether there's some compensatory scheme ahead, I hope so. And this is not a question of just morality or fairness. The point I'm making is that these are also legitimate legal questions in terms of what are rights and part of this whole principle of equality, which I see as a public good in of itself. And I hope we understand, and it's a point that I have to make over and over again. This is not, has nothing to do inequality or even discriminatory policies have nothing to do with intention. You could have the best will in the world, the best intentions in the world. What we look at are the impact, what are the outcomes and results of whatever actions you take or inactions as a policy maker. So I think in terms of our sustainable development goals, equality and economy and so on, we have to reimagine. We have an opportunity to meaningfully engage the rule of law and justice along these lines. Similarly, because it's struck at the very heart of our framework for rights and development and how the two intersect, the issues of the right to health, and perhaps not directly. It may not have been direct in terms of the disadvantages because all of us offer free healthcare. We inherited this from the British. And certainly there were free vaccines. But there are other things in there, like access to water in a pandemic that relied on water and sanitation and so on. The cost of Lysol spray, the medicines, all of these things, when we talk about indirect consequences, we would have to examine. Thankfully, we did not have to confront in any real way, although I'm not saying it doesn't exist, abusive patterns of ethnicity in the COVID-19 epidemic, as we have seen in the US. And we also see links between poverty and race. And I think poverty and COVID clearly came out here as well. We saw that in HIV, not yet so apparent, but not totally absent. I would want to suggest too that although we may pat ourselves on the back in terms of the right of health to the general population, when it came to those most vulnerable in our prisons, and I mentioned migrants before, etc. Again, not a very happy picture. There were even riots because the prisoners complained that they had no running water, they had no soap, etc. And we do know that there were high incidences of COVID in the prisons. So there again, even for persons who are on remand, who might actually be innocent, think about it. So if you had gotten the virus and died while you're on remand because you had, very poor health protocols, etc., then that would not simply be a violation of the right to health, but also perhaps the right to life. So these are very important issues. And the issue of water, and by extension, the right to health in a pandemic, is also important for many of our rural areas and low-income families. In terms of states of emergencies, and of course, all of the draconian measures under the restrictions under the Public Health Acts, I think it's obvious the potential for abuse in terms of civil liberties, but I'm more concerned again about the potential for uneven outcomes. So the fact is that some persons appear, at least it is alleged, the rules seem to be different for some than others. And there were disproportionate, let's say, prosecutions and so on. Something that was the claim. And there's a higher duty of care in situations like this to ensure that there is equality. I remember a case where some children were bathing by the river and they were basically reprimanded and I think a couple were arrested with machine guns. The police came. And not long after, we saw pictures of very elite partygoers who were not harassed at all for lockdown. So these kinds of issues, I think, more than a serious consideration as to whether or not we had to have those laws. On vaccination, I have written so much and spoken so much about vaccination since March 2021, including the likely outcomes. I don't want to go over that ground again in any detail, especially now that it seems that the pandemic is waning. So perhaps it is not such an urgent issue. Suffice it to say that my views stand as to the legitimacy for vaccine mandates and safe spaces under the strict parameters of law, and those views have been validated, though somewhat controversial. And that legitimacy was premised on risk assessments and prioritizing the public health interests within an ambit of proportionality. And those views which I put forward were buttressed by some age-old precedents, such as the Jacobson and Massachusetts case, the analysis of our constitutions, many of which specifically reference public health and infectious disease on grounds for limiting rights in the public interest. And since my thoughts have been put forward there from way back, we have in fact seen a continuation of those precedents, upholding those views all over the world, including in Jamaica and of course the US, the Bridges case, where we have seen deviations, where these mandates have been struck down. It had more to do with procedure and form. So for example, in the US, the Supreme Court struck down the Biden mandates because they used the wrong route. They used the health and safety laws, and also it was a question of whether the federal law could be used to mandates for the states. But it was not the principle itself, not the Jacobson principle as to whether or not you could compel vaccines, etc. In fact, in that same judgment, they upheld, in that matter, they upheld compulsory mandates for healthcare workers. In each case, I think we have seen that the courts were able to correctly balance conflicting rights. They were able to assess legal norms within the context of medical science, such as we knew what the science was, and that's probably debatable. They were able to debunk myths and fake news, ruling in favor in almost every case of the public interest and collective rights. So we did get something right. But I would ask, were these legal victories hollow if a sizable portion of the population was left unpersuaded, disappointed, and unvaccinated? Decisions and legal principles on COVID and rights, actually how to limit rights, were not fully accepted. I think we need to acknowledge that. I think partly because they were not understood by all. And I go back to the concept of rights. What are rights? What rights represent? And so we need to reimagine what law and rights should mean in our society when there are hard choices to be faced, as in that pandemic. And I would also suggest that this basic understanding of law, in order to bring acceptance that it is fulfilling its purpose, means that we have to educate our populations about law and rights. And we fail to do so. There are very superficial understandings of what rights are, the difference between individual rights and collective rights, and what economic, social, and cultural rights, and how these square with these individual rights. That was often lost in the mix. And ultimately, I think the failure here is not so much a letter of the law or the decisions of the courts, but in our attitudes and understandings of law and human rights. And that also requires a reimagining, that missing link. The understanding of rights as shared responsibility and benefit. And that's how I appreciate what the social contract that Rousseau spoke of when he gave us that social contract theory for a rights framework. So no man is an island. In terms of the right to privacy, this was raised a lot during the pandemic on several levels. Not long ago, it was a prevailing view among Caribbean scholars that the right to privacy did not exist in our constitutions. I've always disagreed. In fact, I had a rather public debate with the AG when we looked at a particular piece of legislation. And now, of course, that is now moot, since we've come full circle since the CCJ's Nervous judgment and even the Jones case in the Trinidad High Court. So now there's judicial validity. But while I continue to assert the validity of privacy rights, surely it is one of those rights most easily abrogated, particularly in the public interest. And in a context like this, a pandemic, I am cognizant that there are two equally powerful and legitimate and entirely conflicting jurisprudential trends where privacy is concerned. On the one hand, there's a movement toward more privacy in laws like data protection and so, and on the other, strong movements to undermine, even annihilate privacy, such as in anti-money laundering laws, offshore finance, and you in Bahamas will understand that, and I have challenged that too, emerging whistleblowing laws, all of which undermine confidentiality in the quest for transparency and openness. And yes, while I have been a strong proponent of privacy in certain contexts, in this particular context of the pandemic, I think it forces us to prioritize transparency, to disclose health status, for example, because of public health concerns. In some ways, it's an oxymoron to talk about privacy in a pandemic. Surely, whatever conventions or practices exist, it is necessary to be able to obtain information about a person's COVID status. Is he ill? Is she not ill? Or even vaccination status so as to protect others. Again, I think law must be real. It is not just about abstract principles divorced from reality. And we face this exact dilemma in the HIV pandemic, and many of us, including myself, argued for confidentiality, the complete opposite, privacy. But this had to do with stigma in terms of HIV. Plus, there was no risk of contagion with HIV. That was just a myth. Here we are dealing with a highly contagious virus, and secrecy is misplaced, in my view. And we don't know what pandemics are to come, God forbid. So our laws must be able to accurately assess and address the situations. Privacy must be contextualized. Just in passing, on my last point, I just want to reiterate another gray area, which had to do with compelled vaccines and employment. This whole notion that to compel vaccines or things, any kind of combustion in the workplace would in fact be a breach of the terms of employment, contract of employment. And although I agree that consultation with unions should always take place, I do reject that notion because measures for health and safety to fulfill relevant duties it doesn't always have to be in a written contract because health and safety obligations are also implied into the contract of employment. So to the extent that vaccines or other COVID protocols can be seen as an aspect of that duty to preserve and protect health and safety, which is an implied term existing in the contract, it is not a new term. So it's not any new term being imposed, as has been said elsewhere. And I really would have liked to see the Court of Appeal rule on that. Perhaps we get to see that at some point. Did we overreach in terms of the law? It's hard to say. Were we proportionate in our response? I think I've been invited to talk about that in another discussion about a month from now. So I'll probably leave that there. But it's a time for the reflection. And our experience underscores that law should not be some alien thing. I always tell my students law is common sense. Perhaps it's a bit more than that, but it should be common. We saw in the pandemic how real law is, or how it should be, how it touches everyday lives. And we should be attempting to make those links with law and our societies, that law is a social engineer, not insular. It was so real in the COVID pandemic and experience. Everybody was reading the law, analyzing the law, criticizing the regulations. Did they make sense? And so that's how it should be. Law should create real solutions. So I do think that reimagining law is not just about reimagining laws and regulations, but also reimagining our concept of law and its place in our society, in lawmaking, and the philosophy of law. And I would want us, if it's one lesson that we get out of this, is to hold on to that, to look at the bigger picture, not just the actual rules we write on paper. And that's what when the laws talk about broad purposive approaches and so on, what they mean relating to your broad social objectives. Ultimately, we do have an opportunity to reimagine law and justice, to address structural weaknesses and have a more informed perspective of the realities of the inherently unequal economic and social environments in which COVID-19 and other disasters persist and in which law must operate. We can then, I believe, be able much more ably to protect our societies, including the vulnerable, and promote human rights and justice. Thank you so much.
Thank you so much, Pro Vice Chancellor. That was very interesting, actually. We're going to do the question and answer period now, and I'm not going to use my bully pulpit to ask the first question, even though I'm dying to do so. And for those who joined us a bit late, of course, I'd like to welcome, of course, the judges of the Supreme Court throughout the region. I see we have several. Likewise, we have the Honorable Chief Justice, Sir Brian Morey. I see logged in with us, and the registrars of the Supreme Court. And of course, Queen's Counsel, again, from throughout the region, and students from throughout the region and far abroad. So you have hit quite a wide audience, I must say. I must welcome, of course, my senior tutor too, Ms. Raquel Williams, who I see is in the room along with my fellow tutors. If I don't do that, I'll get in trouble. So I'll make sure I welcome them. Let me ask the first question, and then I will invite the other persons. If you look at the bottom of your screen, you'll see the Q&A. To please post your questions in the Q&A, and then we will channel them so that Professor Antoine is able to answer as many as possible. But I noticed, Professor, when you started with, that law and society thing that we did in faculty way back in the LLB. And law is a tool of social engineering. And I remember in the Caribbean, we always sort of shied away from that because we said, we judges are here merely to interpret the law, et cetera, et cetera. And I found it quite interesting when you spoke about judges having to be aware of, all these facets when making judicial decisions. Could you just expand on that for a minute or two for me, please? Are we going against your tradition? Don't make law?
Not really, but I will invite you to read my piece, Rule of Law versus Ruling by Laws, that I did for the Trinidad Judicial Institute. I think it was called Distinguished Jurist Lecture, which is published because there's a whole long stuff on that. So no, I think there's a thin line between judicial activism, but what I'm actually saying, and I was there talking about in the context of the rule of law, is that we have to have a broader appreciation of even how we interpret some of the concepts in our constitution. So for instance, equality is one of, I suppose, the core ones. And this notion of the rule of law, which to me is not mechanical, but means that in everything you do, and in every time you interpret a rule or a law, regulation, or constitutional provision, you don't just look at the form, but the substance in terms of the rule of law. So if you say you have a right of education, it's not just giving it, but ensuring that there's equal access to it. Otherwise, you haven't really fulfilled that promise of a right to education or any right, dignity as the case may be. So it's really just a broader appreciation of what that means, and not inventing your own substantive concepts of law, but just being more purposive in the way you carry. But I do invite you to read that piece because it's going on and on and on and on.
Indeed, and all persons, of course, who are in the chat likewise. So from Petronella Jack Coker, we have, can it be justifiable for governments to implement specific pandemic laws, for example, mandatory vaccinations, if it best serves the overall public interest? And can such public interest provisions be inserted in a country's constitution so that the pandemic laws will not be regarded as unconstitutional?
Well, I deliberately did not talk about mandatory vaccination, but I see it's still a hot topic. I mean, I touched on it. So yes, I have argued and given several presentations on it. So is it justifiable? So I have said, yes, it's justifiable. Not me personally saying so, but looking at the jurisprudence across the years, and I mentioned Jacobson, which is an old case, and which is still good law, and which even in the recent case of bridges in the United States, it went back to the Jacobson. And I think that's why I mentioned in my talk more than once today that our understanding of human rights is a bit skewed, is a bit insular. that is not, we seem to think that human rights is about individual rights. My right to not do this or my right to do that, whereas rights is a lot more complex. Rights is also balancing of conflicted interests. And I talked about the social contract, that we don't exist alone. So you have our rights conflict with another individual's right. So I mentioned the person who is the worker who is vaccinated, who doesn't want to work next to the person who is unvaccinated. They both have rights. As well, of course, the collective rights, which as the question was, the public interest. And the answer is yes, time and time again, the courts and the law have upheld these public interests. But the only proviso now, which is a more modern interpretation, is the question of proportionality, that you have to demonstrate that it is proportionate and in a simple way, meaning that there was no other way of doing this and achieving your objective. So when it comes to vaccines, and unfortunately it has been true for a lot of the region, if you persuade and you sweet talk and you give everybody free and they still don't take the vaccine, then you have come down to the wire. So it may not have been proportionate to start up and say that everybody must have a vaccine. But if people are not taking the vaccine, and if the science shows that by taking the vaccine, there is a great public benefit, including to you who don't want to take it. One, because you reduce the strain on it. And I've given this lecture many times. I said I was trying to avoid having a mandatory vaccination lecture. But, not just you, but also you're not overwhelming your hospitals, because less people have to go to the hospitals. You have less transmission, because while you can get it, you have less viral load, so less possibility of infecting others, less death, etc., etc. And risk, the risk factors. And when the court looks at that, and the court looks at the medical science and listens to all the other things which they would treat as propaganda, I'm sorry, that's what they would do. That's what they did in HIV. That's what they did in all of these sorts of things. And so all these other things about what's his name in that fella in Microsoft, not Microsoft, his name escapes me now, the millionaire. Okay, whether he's the one trying to inject us, they would dismiss all of these things and simply say, no, when you assess, when you balance, it is not unconstitutional because it is reasonably justified by the public interest. Whether you can, and that has been proven, all of the cases, I can't think of, that is still the precedent, that is still good law. And again, as I mentioned today, to some constitutions specifically talk about that you can limit your rights for infectious diseases. And I'm spending some time, because I suspect other people want to hear about this too today. You can limit your rights to protect against infectious diseases and public health. Those are specifically enshrined in many of our constitutions. So those two things. So in a sense, you don't even need to change your constitution, because the constitution already, not all, but many do in fact specifically give the courts that leeway. So there you have it. So it's not just your individual right, and the cases do go in that direction.
Thank you very much, Professor Antoine. So the question is now being asked with regard to the public health regulations. Many of them seemed quite unclear, and that there were several persons, ministers of various sorts, all attempting to provide clarity. So the question has been asked now, shouldn't it be, or whether it should be, the sole responsibility of the Attorney General to speak to that sort of clarity? In other words, as he is the official lawyer for the bar, for the country, for the government.
Well, that's like a political trap question, but let's get it. Well, if I were technically correct, I would say it would be for the courts to determine what is the right law. But I suppose you don't want to go there. Not yet, as you well know, Parliament writes the laws, they don't interpret them. And that is why laws have to be clear and concise. I didn't know you had that problem. We had some little mishaps too in Trinidad, but yes. And I think that underscores some of what I said in terms of, to be fair, this was such an unusual landscape. We were searching. There's a lack of clarity, even when we try to produce solutions. But the correct answer to that, no, the Attorney General can in fact attempt to clarify. But ultimately, if you wrote the law in a particular way, and when the clear meaning says that, it's the justices on this webinar who are going to interpret it and say, I don't care what it is you think you said, but this is what you said. And I'm sure you'll jump in and agree with me.
I love that. I don't care what you said. That's what you say. Well, I'll go on very
That's what
quickly.
statutory interpretation is. What
I'll
is
go
a
on very
clear
quickly.
meaning? That's it.
There's a question here that's been asked by student Diana Ferreira with regard to the employment law. And she indicates that it is evident that COVID-19 has exposed some labor laws in the region in terms of contractual employment. Do we now suggest that labor laws need to be amended or new laws enacted? What are your thoughts?
That's an interesting question. Do we want to have, well, you know, I did say this whole contract model is a waste of time, basically. So that would point to a whole new, I know there are some scholars, just a few of us, who love to talk about that. Whether it's feasible at this point, it's not clear to me, but they certainly do need to be amended at the very least. And I think I've shown you enough examples as to why that is so. And there, I think we also need this whole rights analysis that the ILO has been trying for years to talk about rights and rights. It doesn't sit comfortably with the legislation we have in the region. I think we need to have a deep dive in our labor laws. So it's not just a little piggly wiggly type of amendment, but deep reflection on some of them and where we at, and not be too legalistic. You know, because and even some of the unions, I felt sometimes unions in the region were losing sight of the bigger objective in some of the things that they were trying to say. And oh, but you know, there's a decision here that says you can't do something, can't do, forgetting the objective. So for example, if you push too hard when an employer said, but let's reduce hours, or in order to not terminate people, and you push too hard, what happens is that you lose out, because as I explained to you, in many cases, it was easier to terminate than to vary or be flexible. So yes, we need some reform.
Okay, thank you very much again, Professor. So I'll take this from Mr. Anthony Gaffur, who asked, can the law balance the individual entitlement to the right of a board as citizens with the jurisdiction of the state to close national borders?
But that whole episode gave me some angst, I must say. I suspected, because incidentally, for those of you who don't know, because it didn't happen in every country, but Trinidad and Tobago closed its borders for a very long time. Not all countries closed their borders in such a dramatic way. And so many citizens were left stranded, often for very long periods, months and months. Some of them said they had no money. A couple of them, I even heard stories of one or two had no medication. One or two might have died. Who knows? It was all very unclear. And the citizens who were in Trinidad weren't very sympathetic. I must tell you, many of them weren't. So yes, keep them out, keep them out. Of course, in the end, we all did get the COVID in full blast once you open. But the reason, of course, was to try to preserve, to keep it out, and also to, I think, to preserve the hospitals, because they were afraid of the hospitals. I am very conflicted with this one. I suspected that the courts would say, okay, public interest, which is what they did, because it was challenged in courts. It was challenged before the courts, and they lost every case. On the other hand, it is hard pressed, and this is not just place of abode. I think it has to do with citizenship. Your right to residence, you're a citizen of a country. And it is, in some ways, I suspect if we had had an international law court or tribunal, there might have been a different answer. I suspect so, because that whole question of your right as a citizen, citizenship. But I have to be correct and say that the courts did rule on this matter, and they did rule that it was not unconstitutional.
Okay, so I will take the question from student William McFord, who asks, and this of course is a labor matter, the question of, I guess, employees being caught between a rock and a hard place, in the sense of employers not enforcing proper COVID protocols and employees having to come to work in those circumstances. Of course, the option, if you do not come, as you said, perhaps termination or some other form of punishment. So what are your thoughts on that?
Well, technically, I mean, in theory and in law, You could have sued your employer on two fronts: one, breaching the health regulations, and two, you breaching your terms, contractual terms to promote health and safety at the workplace. So that was two ways you could have sued. But in real life, you could have sued and probably would have lost your job. So I don't know. Clearly, this was wrong. This was a question of enforcement, and that is something that happens. That we have nice laws and they're not enforced. So that is unfortunate. But yes, there would have been solid claims to sue, and there are remedies in law in two avenues: both the public health regulations, which the police could have been called in, um, and the labor law. You could also, it's something I explored in some, and I can't recall offhand whether your Employment Act has it in terms of the health and safety, because I didn't interpret this as only a Bahamas lecture, so more like a broader perspective. But several of our health and safety, the more modern versions laws, have provisions where you could refuse to work and you could walk off the job, of course, for health and safety. Yeah. So to that extent, yes, you could say, well, I'm not coming to work until, and you're in your right. But that these are very nice sounding solutions. I suspect these are vulnerable workers and would have had little recourse. But in many jurisdictions, and even under the common law, if there's a imminent danger to health and safety, such, and if you could categorize that as such, then yes, you could have pursued that as well.
Okay, well, that Professor, that brings me actually directly to the next question, because it's been asked, if an employer imposes a mandatory vaccination requirement on its staff, given the current availability of various vaccines, is it justifiable for an employer to terminate employees for not being vaccinated?
Well, I thought I'd already answered that yes, mandatory vaccines are typically upheld in law and even in the private sector. And I also spoke rather hurriedly at the end to that claim that came up about when you're breaching a term, because there's nothing in my contract that says they force me the vaccine. And I did say to you, that might be so, but there's an implied term, health and safety. So if you could say, okay, you having a vaccine is my way of ensuring health and safety at the workplace, then it is justifiable. So yes, but I should sort of temper that by saying that it's certainly in this pandemic, the question of risk has been important. So it is really in those work environments where the risk is highest. So for example, if you're working side by side, your faces close to each other, things like that, or it's difficult to institute COVID protocols, those have a better chance when the employer says, no, you have to be vaccinated or you have to do ABC, get a test. It is so this is why in almost every case, I can't think of one that went the other way, say the health sector. In all of those cases, the court said, no, you can mandate, even for the private hospitals, yeah? But one could see, because we've premised those arguments on risk, one could see that in some work environments, a court could say, and it would be nice if some of the judges, I suppose they can't prejudge issues, but a court could, in theory, say, well, if there's no great degree of risk, then it is not proportionate to fire someone for that. So those are the sort of the issues that you would need to look at.
Okay, thank you. And the question now being asked is...
Interesting questions.
There's a lineup. In your discussion, you mentioned that the way in which education had been handled, whereby students still had to do exams, what would have been...
Sorry, I missed the first part.
Oh, yes, from Lisa Lewis. In your discussion, you mentioned that the way in which education had been handled, whereby students still had to do exams, what would have been the proper way to deal with this situation?
Well, I mean, I think I do believe that those persons, I thought I saw in the news this week, I only caught the end, that Barbados were thinking about something to do with students who wanted a do-over. At the very least, I would have thought that students who were able to say, look, I didn't really get my instruction this last year because I had trouble with my not having a phone or a laptop, whatever, that they would have an opportunity to do the exams in next year without any sort of penalty. I know at the university what we did is when people failed, we didn't count the fail. You could do over, etc. And we gave them the option of not doing exams, and so I know that would have been tiresome, to say the least. And there will be issues to do with, I imagine, spaces at school. I'm talking about physical spaces when we start back and so forth. It's not an easy option. And I do empathize with ministries of education, etc., and ministers. But I do feel for those students. And as I said, I sat out there in front of my television every night, listening to these and watching these stories of these children trying to get access. And I experienced it as well in my laptop, in my faculty. What am I saying? So I do believe some sort of compensatory scheme. I'm not suggesting delay all of the exams. I mean, some of them would have been ready and prepared and could go ahead, but at least a do-over or a delay in those who said, look, I'm not ready, I can't do it this year because X, Y, and Z. To me, that would have been appropriate. And that is not a legal question, but that is what I would have done.
Yeah. And the question is now being asked by Petronella Jack Coker: how can international and domestic humanitarian laws be strengthened to ensure that persons, for example, refugees and the internally displaced, are offered optimal protection during global health crises, such as the COVID-19 pandemic, to guard against the very inequalities you spoke of?
Very good. And in fact, I was going to talk a bit about migrants, but I felt that it was been too long. But compared to the HIV pandemic, there was an improvement. And you mentioned in introduction that I had done that HIV migration curriculum thing, and that was one of the main things we were pushing there, that countries cannot say, and especially those with huge migrant populations, I know Bahamas is one, we only going to give medical treatment and so on to our nationals, and so especially when it came to HIV treatment and some of those kinds of things, because it is not in the interest of the public. It is in the public's interest to give free and make it accessible to refugees, migrants, even undocumented ones, because then they're the ones who could then reinfect or infect the public. So it's a bit silly to not do it. And we had this project, we worked on that when HIV, and I was happy to see, I don't know if it happened all throughout the region, but certainly in Trinidad and Tobago, migrants have free access to vaccines and everything else. I don't know if any of them, when they got COVID, got into the hospital. It was certainly never reported, and I'm assuming they would not have been turned away. But I know they got vaccines, and that's the correct approach. And it's not altruistic or humanitarian alone. It's also practical because of public health imperatives. The public health people tell you that's what you should do. So yes, that's a great question. I'm glad it came up.
And the question is now being asked: what is your view on national insurance and national health insurances, including pandemic benefit, to alleviate the strain on, under, and during unemployment during these occasions, like going forward? What about that?
Yes. Well, I wouldn't want to prescribe what kind of social security net, but it could be that would be one form. Yes, pandemic insurance or some sort of emergency disaster, because we have to cater for the hurricanes and so forth. It's not just the pandemic that can do a lot of the things that we saw happen here. So yes, something around that thing. That's why I mentioned unemployment insurance and so on as a viable option. I tend not to like national insurance only because of what I just said there about migrants, is that they tend to want to get you have cards and you must be a citizen or a national to get access, which is counterproductive. So that would be my only concern about that one. But certainly some sort of social security net and safety net would be appropriate and is necessary at this point in time. And perhaps for those many countries that don't have severance pay funds, we need to have something like that.
And I guess this question comes naturally after that, because it's now been asked with regard to labor laws. Are you in favor of more flexibility in labor laws to better protect the rights of employees Or is it that you're looking to protect the rights of both employees and employers? And how will that balance?
Right. Well, I mean, we have been trying for centuries to get labor law and industrial frameworks to balance and have equilibrium. I don't know if we ever succeeded or ever will. But yes, I mean, I think both employers and workers, I would like to see that sort of balance and fairness. But I am not suggesting carte blanche flexibility, because if you say it like that, you could go back to a laissez-faire type of approach where let the market regulate, which is not beneficial to employees. We've seen that. And we need to have the unions, and we need to have the sort of fairly restrictive or prescribed, I should say, frameworks. But what we do need to have would be those sort of safety clauses or emergency clauses, provisos in there for an emergency. So, you wouldn't have one to write, you have to define what emergency means and so on. But in those situations, you would want to have flexibility. So I'm not saying open it up, let everybody do what they want, change the conditions of work, decide you must have a vacation. No, I'm not saying that. I'm simply saying it must be flexible enough to be able to work when you have these emergency types of situations which require that approach.
Indeed. And the question being asked is with regard to your comment on the states of emergencies and public health acts, the possible concepts or questions with regard to the abuse of civil liberties and the uneven outcomes. How do you think that could have better or be best managed?
Well, I think in terms of those uneven outcomes, it is a feature of the wider sort of subtopic that I was talking throughout my presentation, which is these structural inequities in our societies, which we see manifested in every facet. So I don't think it's an accident that the police or anybody would target certain sectors of the society more than they would target others. It's not an accident. It has to do with marginalization, poverty, inequities, all of these things, who is vulnerable, who is powerless, etc., etc. So that's that. Apart from that, I wasn't suggesting that the laws themselves were abusive or too much. I think that I have been invited to, I don't know if it's a panel or what, I can't recall. The CLA is having something next month. I'm giving them a plug free of charge. And they are going to be looking at, whether we overreacted in terms of the laws, which is an interesting question. So that is also part of how we should reflect. Did we overreact in some ways? And something I would look more into. But yes, I think that abuse thing has to do with these structural inequities, all kinds of biases in our societies, unfortunately.
And we're at 9:29, so I know we are coming down. So an attendee in the room asks this question. If I am damaged from a COVID-19 vaccine that my employer has made mandatory for me to take in my workplace, who pays for the damage that I have sustained?
A lot of people ask that question, not to me personally, but I know it was asked to the minister here. I think the unions asked that, and apparently they are looking into some kind of liability, but I was a bit surprised that they were. But I don't know the answer to that, I am afraid to say. I really don't. Because I don't think it could be the employer, because if there's a national trust to say this is what we expect as a public health imperative, so, but just for your information, that question, it's been asked time and time again, this liability, because when you tell people the vaccines are safe, many people don't believe, and of course there have been incidents, as with every medication under the sun, by the way. And so that question has come up, and I heard our minister here say something about he's looking into this question, so I'm awaiting the answer to that too.
Okay, Professor Antoine, it's 7:31 now, and we've had you for a full 90 minutes. And I think we will sort of round off here. And I will invite the Year 1 student of the Eugene Preach Law School, Mr. Darren Cash, to come on and give the vote of thanks, please.
Thank you very much. Good evening, ladies and gentlemen, and a very special good evening to you, Pro Vice Chancellor and Professor Belle Antoine. On behalf of the principal of Eugene DePuche Law School, Ms. Tonya Bastian Galanis, our senior tutor, Mr. Clive Guy, all the faculty, staff, and the privileged students of EDLS, and of course, on behalf of all of our distinguished guests, I wish to say a heartfelt thank you for an outstanding presentation. It is perhaps fitting that when many of us boldly entered a new frontier called the study of law, we did so by first immersing ourselves in a textbook entitled Commonwealth Caribbean Law and Legal Systems. The book covered a comprehensive and dynamic spectrum of issues and was just what a new Caribbean law student needed as he or she sought to conquer this new frontier. It was thought-provoking. For example, since then, I don't think I've come across another book that examined the role of the slave in creating modern law. As I said, thought-provoking. Ladies and gentlemen, of course, the author of that book was our esteemed speaker, Professor Rosemary Belle Antoine. Now, Professor, even though they taught us in contracts that past consideration is no consideration, we still want to say thank you for brightening the path as we entered that new frontier of the study of law some years ago. This evening, we have very good reasons to say thank you again. As we all embark on a new era of the practice of law, and as all of us sit behind our electronic devices, it is clear that this is also a new era of the study of law in the post-COVID-19 era. We are again privileged to have had the benefit of your wise and well-considered words of wisdom and guidance. As expected, you left no stone unturned, no major issue unexplored. Some might say you touched all of the pain points. This much is certain. You've given us food for thought, whether it's on labor law reform, privacy rights, equality, structural inequities, social security, dare I say it, cannabis, and that waste of time contract model. You have indeed helped us to reimagine law after COVID-19. And in fact, I think for many of us, you've helped us to shape our vision for the roles that we can play. And perhaps I should borrow the words of William Damas, the roles that we should play in the process of change and renewal. So again, on behalf of Principal Galanis, Senior Tutor Guy, and all of our colleagues in EDLS, I want to say thank you for enriching our evening, our knowledge of law, and yes, we look forward to seeing you in person in the Bahamas. Thank you very much.
Thank you so very much, Darren. And I will very quickly turn the floor over to Principal Galanis to say our good nights. Thanks so much, Professor Antoine.
Thank you and good evening.
Thank you.